Good evening, very dear friends. It's quite long. So, we are back again with our regular sessions now onwards. And, friends, in today's session, we will deal with a part of the relationship between banker and customer. In this topic, which is part of your syllabus, we are starting off the Unit 2. Hopefully, by 15th of next month, we'll be completing this particular portion. We earlier discussed about the banker. Once again, I will take you round with regard to who is a banker. In the generic meaning, the business of banking itself is called banker. Section 3 of the Negotiable Instruments Act 1881 defines the banker as includes any person acting as a banker. That means we have to then go in search of a clear-cut definition of banker. So, Section 2, subsection 2 of the Bankers Books Evidence Act 1891, I already told you to get these particular books also, defines a bank and a banker as any company or corporation carrying on business of banking, any partnership or individual to whose books the provisions of this act shall have been extended as hereinafter provided. Any post office, savings bank, or a money order office also could be taken as a banker. That is the reason why, in fact, now it is called post office savings bank. That is how the nomenclature has come. And then, friends, I will take you through the Halsbury's Laws of England, which defines the banker as banker means any person carrying on a banking undertaking as may be declared by order of the Treasury to be a banker. Actually, I have given a very elaborative explanation on the word banker and its origin, its derivative, bankers, bench. I think you can remember our earlier lectures on this subject matter. Friends, the term banking is to be viewed as synonymous to the word banking company also. So, banking, banker, banking company. So, we are now going forward in the subject matter. Subsection 9 of Section 2 of the Companies Act 2013, there is a new legislation, friends. A banking company is defined, which states that a banking company means, quote, a banking company means a banking company defined in Clause C of Section 5 of the Banking Regulation Act 1949, unquote. That means the banking company is basically defined under the Banking Regulation Act. This is what I told you earlier also. The regulator is RBI and the regulating legislation has to be the Banking Regulation Act, read with the RBI Act in this regard. Now, what is this Clause C of Section 5 of the Banking Regulation Act? Quote, it defines a banking company as any company which transacts the business of banking in India. Under Clause B of Section 5 of the Banking Regulation Act, banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order, or otherwise. Unquote. So, friends, here Clause C clarifies that any company accepting deposits of money from the public merely for the purpose of financing a business shall not be deemed to transact the banking business. It means basically accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise and withdrawable by check, draft, order. This is not possible with NBFCs. That is the reason why they are not banks. Under Section 7 of the Banking Regulation Act 1949, only a company registered under the Companies Act or a cooperative society or a statutory body like the State Bank of India can carry banking business in India, and every such person must use as part of its name or in connection with its business any of the words bank, banker, or banking. So I have just reviewed the word banker, banking. Earlier I have already dealt with this elaboratively. Lectures are available in YouTube. Now we are talking of the banker and customer relationship. So I will now take you to the meaning of customer. A customer is one who avails the services of a banker. This term is elaborately discussed, of course, at length in my future lectures. Prima facie, the customer's definition says that he is one who avails the services of a banker. What is the legal relationship subsisting between a banker and the customer? This is the most important question for the lawyers, lawmen. Basically, the nature of relationship between a banker and the customer is contractual. This is the most important thing. This is the most important thing. It is basically contractual. The relationship between a father and son is non-contractual. It's an undefined legal relationship. But a banker and customer is a defined legal relationship with regard to contract. That's why it's contractual. This aspect was well analyzed in the English court judgment in Joachimson, Joachimson, Joachimson versus Swiss Bank Corporation. The citation is 1921, Volume 3, the decision of the King's Bench, page 110. According to this particular legal relationship, we find that a banker carries all the functions of a banking. A banker carries all the functions of banking enumerated earlier in my earlier lectures. And it also pertinent to note that the banker must invariably follow the Negotiable Instruments Act 1881 and also other banking legislations. And the relationship could be taken into different segments. What are those segments? The first segment is that the relationship of banker and customer as a debtor and creditor. This is the most important thing. Who is the debtor? Who is the creditor? It changes intermittently. For example, the amounts of deposits made with a banker by the customers, he stands as debt to the banker towards the depositors. And the customer, as long as he maintains the balance in the respective account, the banker is to be termed as a debtor, and obviously, needless to say, the customer is the creditor of the particular banking business. Only the pertinent issue here is the customer remains as unsecured creditor unless his deposit is insured under the Deposit Insurance and Credit Guarantee Corporation scheme and insured by the Deposit Insurance and Credit Guarantee Corporation. Then, friends, by granting loans, discounting of bills, overdrafts, etc., the banker becomes the creditor. It all depends upon the understanding and the contractual arrangement made between the parties with the banker and the customer. Then, friends, this particular relationship is different from the similar relationship arising out of ordinary commercial debts. As in case of banks, the banker does not repay on its own accord, it should be only by demand. So the banker is called technically a privileged debtor. You can get a question tomorrow. The banker is a privileged debtor. Explain. Then you have to say he won't pay on its own. The bankers won't pay on their own. They will repay only on demand. They don't repay on their own accord. Then customer as a creditor must make a demand for payment of his deposit in whatever account, SB account or whatever it is, in proper manner at proper place and time as stipulated under the banking rules with regard to the functioning of banking working hours. And this aspect was well emphasized by the English court in Joachimson versus Swiss Banking Corporation, which I have already referred earlier, and then I have given the citation that 1921 3 King's Bench 110 is the page number. So, friends, here is the case where the relationship here is taken as the banker and customer as number one, the debtor and creditor. Once the banker grants loans, then the banker will become creditor. As long as there is a positive balance maintained by the customer, the banker is a debtor. The banker gives loans, he is a creditor. Now the second type of legal relationship, whether bankers can be termed as trustees. Now, once it is a trustee, automatically the Indian Trust Act 1882 comes into picture. And under the concept of trust, a trustee holds money or assets of the trust to perform certain functions for the benefit of the beneficiary. And then in this particular banking issue also, the multifarious functions bankers are now discharging. The banker acts as a trustee for the money, the securities as well as the valuables deposited by the customer. That is where the trusteeship comes into picture. However, the banker is not the owner of the said properties, unlike a trustee. Trustee is the owner of the properties. So the customer continues to be the owner of his properties deposited. That is the difference here. Banker acting as a trustee, but with a difference with the regular trustees. So this particular trusteeship concept was in fact examined and then analyzed by the Supreme Court of India in the case of New Bank of India versus Pare Law, which was reported in the All India Reporter 1962, Supreme Court, page 1003. Here the banker is called a trustee for the reason that he discharges fiduciary functions. Then here the Supreme Court distinguished the banker's role as a trustee from a debtor, and then it was analyzed further in the Shanti Prasad Jain case versus Director of Enforcement. The reference is 1963, Volume 2, SCR 297. 1963, Volume 2, SCR, page 297. Now, friends, in the legal relationship of banker and customer, we are now discussing about the banker and customer relationship. What are the legal relationship that exists? Then the first point is that the banker as creditor and debtor. Now the legal relationship as a trustee. This is the sequence you are supposed to write in the examination if that question comes. The third one is the banker acting as an agent. Agency means the Indian Contract Act comes into picture. Like today, all kinds of functions are being carried by the bankers can pay our bills also. So they are our agents. They can negotiate and then get and enter into real estate transactions. So the banker today buys and sells securities on behalf of his customers and also collects checks and makes payment for various dues. So the banker discharges the functions of an agent of the customer. This is where the law of agency comes into picture. Here, the relevant citation is the Madras High Court judgment in Travancore National and Quilon Bank. Travancore National and Quilon Bank, that is Travancore National and Quilon Bank. It was reported in All India Reporter 1940. All India Reporter 1940. Madras High Court, page 139. Now a question comes in this way, whether the banker can refuse to provide services. In normal parlance, the banker cannot refuse to provide its services to a customer unless there is a valid reason. Otherwise, it's a public office, he cannot say no. This point was well emphasized by the Supreme Court in its decision Purewal and Associates versus Punjab National Bank. Reference citation, All India Reporter, 1993, Supreme Court, page 954. Then friends, the banker also in the fifth phase can act as an advisor and manager. In the modern times, he can play as financial advisor, tax consultant, and public issues manager, merchant banker, manager of mutual fund properties, organizer of various issues, and all these multifarious functions can be, in fact, handled and then can be performed by the bankers in today's scenario. Then another very important aspect is the banker acting as bailey under sections 148 to 181 of the Indian Contract Act 1872. Because there are a number of services which are offered, the banker is termed as a bailey, and then all the provisions of bailment under 148 to 181 apply to the banker also. This is emphasized by the Supreme Court in United Commercial Bank versus Hemachandra Sarkar. This was reported in All India Reporter, 1990, Supreme Court, page 1329. Where the banker is termed as a bailey. The last point of banker and this customer relationship with regard to the legal relationship in different capacities, like the creditor and debtor, and then the trustee, then the advisor and manager, bailey, and then the agent. So other services, the bankers are discharging multiple functions like bills, collecting checks, discounting them, acting as executors and trustees of wills, issuing travelers checks, bank guarantees, credit cards, factoring, and various business as well as personal services. So the legal status is in fact determined as per the appropriate contracts and the terms and conditions thereon. So friends, with this background, I think we can conclude our discussion on the legal relationship existing in multifarious facets between a banker and customer. I will take up the other subject like the duties and liabilities of a banker. This is most important subject again in the examination point of view, which I will take up in coming lessons. So with this, we'll close the session today. Thank you very much and goodbye, good day. Bye-bye.